Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about tortious interference with the expectancy of an inheritance and fraudulent inducement. These are claims that are common in Illinois probate disputes, and they're causes of action that are brought against individuals who wrongfully deprive the plaintiff of their inheritance. So they take some wrongful action to get rid of an expectancy, an expected inheritance that the plaintiff otherwise would have received. We're going to talk about the elements of tortious interference with an expectancy and fraudulent inducement, the differences between the two claims, and how they interact with will contests and probate litigation. So first, let's talk about our example from last time. We talked about the Dead Man's Act, and in that video, we talked about the dispute over Batman's estate. Batman had been knocked off by the Joker, and now Nightwing and Robin, who were his adopted children and wards, are fighting over his will and who's going to inherit Wayne Manor. So we can use that example again in this case. So in this case, let's assume that Robin knows that Nightwing is alive, but lies to Batman and tells Batman when he's making his will that the Penguin had killed Nightwing. He had died honorably in the course of battle, but he's dead and he's out of the picture. And then when Batman makes his will, thinking Nightwing is dead, he leaves the Wayne Manor to Robin. If he had thought Nightwing was alive, or if he had known Nightwing was alive, Robin and Nightwing would have split Wayne Manor. Batman dies. The Joker finally knocks him off, finally wins, and now Robin and Nightwing are fighting in court about Batman's estate. And Nightwing is claiming that he's suing Robin, claiming that Robin's false statement caused Nightwing to be disinherited because Batman thought Nightwing was dead when he actually wasn't. So that's a classic example of both tortious interference with an expectancy of inheritance and fraudulent inducement. And now we're going to pick apart the elements and explain why. So let's talk about tortious interference with an expectancy first. There's 6 elements. The first is that there must have actually been an expectancy. An expectancy is a potential inheritance directed towards the plaintiff. So because Nightwing and Robin were both adopted sons of Batman, they had a reasonable expectation and expectancy of inheriting part of Batman's estate. So in this case, there was an expectancy. The second element is interference by the defendant with the expectancy. So Robin had to actually insert himself and say something to interfere with Nightwing's inheritance in order for tortious interference to apply. The third is the defendant's interference must have involved tortious conduct, such as fraud or undue influence. This is really important. So the action had to have been tortious in itself. The action had to be wrongful in itself. The action that caused Batman to disinherit Nightwing. So, for example, if Robin had told Batman that Nightwing was dead, and Robin actually believed it, Robin's statement isn't wrongful. He was just mistaken. He isn't committing a fraud. Therefore, there wouldn't be any tortious interference. And that's similar to the fourth element. The interference must have been intentional. So if Robin just made a mistake in saying Nightwing was dead, there's no tortious interference claim. The fifth element is that there must have been actually reasonable certainty that the plaintiff would have inherited had the defendant not interfered. So in this example, Nightwing is Batman's adopted son. It's reasonably certain he would have gotten some of Wayne Manor's estate. If you switch the example around and basically have Superman making a tortious interference claim, there's no likelihood, even if Robin lied to Batman and told Batman that Superman had been killed by Doomsday, even when he hadn't, there's no real reasonable certainty that Superman would have gotten part of Batman's estate. They're friends, they're buddies, they're on the Justice League together, but Nightwing is Batman's adopted son. Superman is just his friend. There's no reasonable certainty. Therefore, Superman probably wouldn't have a reasonable claim for tortious interference. And finally, the plaintiff must have actually been damaged by the defendant's interference. So if there's no money in the estate, then there's no damages. If Batman doesn't actually change his estate to write Nightwing out of his will based on Robin's conduct, then there's no damages. There's no claim for tortious interference. So usually tortious interference comes into play in the context of someone messing around with another person's estate plan and doing something wrongful to disinherit somebody else. But it can also come into play in two other contexts. One is interference with gifts that otherwise would have been made to the plaintiff during the lifetime of the deceased individual. These are known as inter vivos gifts. And in this example, if Batman was going to give $100,000 to Nightwing to get him a new crime-fighting uniform, and Robin said, you know what, he's a villain now, he's working with Lex Luthor, when that isn't actually true, and based on Robin's false statement, Nightwing doesn't get that gift, doesn't get his new suit, he can then sue Robin for tortious interference with an expectancy, the expectancy being the gift instead of the inheritance. Another example is if someone fraudulently or wrongfully induces the deceased person during their lifetime to make a transfer during an inter vivos transfer, a during lifetime transfer to them that diminishes the estate, basically reducing someone else's inheritance. That's another example of tortious interference. So in this example, let's say Robin basically makes some false statements about what he's doing for Batman, saying, Robin tells Batman, you know what, I'm going to soup up the Batcave with, if you give me $100,000, I'll buy us some new equipment. Robin never intended to buy the new equipment. He spends the money on gambling, and it was just a false statement to induce Batman to give him the gift. Then Batman passes away, gets knocked off by Joker, and that $100,000 is no longer in Batman's estate. Nightwing would have otherwise inherited half of it. Nightwing can sue Robin for tortious interference with an expectancy because Robin wrongfully diminished the estate by fraudulently getting Batman to give him that gift of $100,000 when he, in fact, had no intention of souping up the Batcave. So that's tortious interference with an expectancy. Let's talk about fraudulent inducement. There are 5 elements to fraudulent inducement. You'll see that the claims are very similar. We'll talk about the differences after we go through all of the elements. First is that there must have been a false statement of material fact. A material fact just means an important fact. So the defendant must have actually made a false statement. Number 2 is that the defendant must have known or believed the statement to be false when the statement was made. So this is, in this example again, Robin must have actually known that Nightwing was living when he told Batman that Nightwing was dead. Third, the defendant must have made the false statement with the intention of inducing the deceased individual to act. So the statement must have been made not in just an offhand, joking sort of way, but with an intention to get Batman to change his will to write Nightwing out of it. Fourth, the deceased person must have acted in reliance of the truth of the defendant's statement after the statement was made. So it's not good enough that a false statement was made. Batman must have actually relied on that statement in changing his will. So if Batman knew the whole time that Nightwing was alive, even if Robin lied to him, and that wasn't the reason he changed his will, Robin's lie, then you don't have fraudulent inducement. Finally, again, damages. The false statement must have resulted in a diminution, a reduction of the inheritance that would have otherwise gone to the plaintiff. And again, so if the will isn't actually changed, or if there's no money in the estate anyway, you don't have fraudulent inducement. So really, when it comes down to it, what's the difference between tortious interference and fraudulent inducement? The big difference is that tortious interference can encompass a wide range of wrongful behavior. Remember, there's still got to be wrongful behavior. It's not enough that someone just went in and befriended Batman and got Batman to leave them everything. If it was of Batman's free will and there's no wrongful conduct, then there's no tort. There's got to be wrongful behavior, but tortious interference can be any sort of wrongful behavior. It can be undue influence. It can be any other tort or crime. Fraudulent inducement is kind of limited to false statements of material fact, fraud. That's the big difference. There's some differences as far as the statute of limitations that we'll talk about in just a second as well. But other than that, it's very, if it's a fraudulent statement that's at issue, it's going to be the same set of facts that you're going to have to prove for both. So now let's talk about how tortious interference and fraudulent inducement work with will contests. We have an article and video about will contests. They're basically disputes over the validity of a will. Someone claiming that a will is invalid, and it can be again, often the same set of facts proven for these torts that we've been talking about and a will contest, but they're slightly different. One difference is that a will contest goes on in a probate estate, and a tortious interference claim can go on in conjunction with a probate estate too, but the claim for tortious interference or fraudulent inducement is actually against the defendant. You're seeking money from the defendant for something that they did wrong, rather than necessarily just from the assets in the probate estate. The remedy for a will contest is to invalidate the will. The remedy for one of these torts can be actual money damages to be paid by the defendant. They also work differently with no contest clauses. So we have a video about no contest clauses if you want to learn more about those. But no contest clauses are basically clauses in a will that say if you challenge the validity of a will and lose, then any inheritance you would have received under the will, you're not going to get anymore. You're disinherited. No contest clauses apply to will contests. They don't apply to tortious interference or fraudulent inducement claims. Again, because you're not necessarily challenging the will in the probate estate. You're not actually having a will contest. You're just suing the defendant for the wrongful tort of interfering with your inheritance. Finally, and probably most importantly, the deadline to file a will contest claim is 6 months after the will is admitted into probate. The deadline to file a tortious interference claim that doesn't deal with probated assets is 6 years after discovery of the wrongdoing. The deadline to file a fraudulent inducement claim is 5 years after the discovery of the wrongdoing if the claim doesn't deal with probated assets. Now, when I say deal with probated assets, when you're going through a probate case and you're seeking distribution of the probate asset, if your remedy is to distribute the probate assets differently rather than have the defendant pay you money from their own assets, you've got to actually work through the probate case, and the probate deadlines will apply. We've got lots of videos and articles about probate and will contests and how those deadlines work, so we'll leave that to those articles. But the bottom line is that tortious interference and fraudulent inducement claims are claims that can be made against a third party, often in conjunction with will contests and probate litigation, but they can also be made separately. They can be made after the conclusion of probate litigation, and they're made, usually against the third party and their own assets that they wrongfully got through the interference with the expectancy. They're very similar. Tortious interference is a little broader in the type of wrongdoing. But the bottom line is if someone comes in and inserts themselves and does something tortious and wrongful to disinherit you and reduce or eliminate the inheritance you otherwise would have received, you may have a claim for tortious interference or fraudulent inducement. Thanks so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.